Welcome to the Ohio Eviction Playbook.
Hello, everyone, and welcome back to the Ohio Eviction Playbook with Ed Kasputis. Ed's a longtime Ohio attorney, former state legislator, and the founder of Kasputis Law Firm. He approaches evictions through both a legal and business lens, helping landlords and investors avoid costly mistakes. I'm Sean O'Connor, and today, Ed and I are talking about security deposit accounting. Step by step, getting into it in detail. Ed, good to see you.
Good afternoon, Sean. Thanks for having me.
You bet. Let's talk about what can a landlord do with a tenant security deposit and what obligations follow once the tenant moves out. This is always anybody who's rented, and they're like, oh, I hope I get my security deposit back, and all that tension that happens.
Well, I mean, if you're the landlord or the tenant, you want to give the property back in the same condition as when you got it, less normal wear and tear. And the million-dollar question is, what is normal wear and tear? And if I had 10 municipal court judges behind me, they'd all say, I know it when I see it, but I don't know how to write a formula. And one of the things that's tough when we have a trial on damages is that it isn't one trial, it's 50 trials. And it's like, what do you mean? We're having a trial about the carpet. Yeah. Now we're going to have a trial about the cleanliness of the place. Yeah. Now we're going to have a trial about the windows, on and on and on. So if you're a landlord, you must document. And you know what? If you're a tenant, document. I've had tenants come to me saying, my landlord made these outrageous deductions. And it's like, did you do a move-out inspection with the landlord? No. Did you take pictures? No. Oh, you're killing me. What am I going to do? So both sides need to document, but in a perfect gentlemanly world, you also have a mutual move-out inspection, but many times people don't want to make eye contact with each other, and they slide the keys under a door and run.
Does a landlord have to apply the security deposit toward unpaid rent or damages, or do they, is there some wiggle room? Do they have discretion in how they handle it?
If we're in law school, the answer is you have discretion. If we're in the real world, a landlord would go, why do I want discretion? If I think I've been damaged by $1,000 and the security deposit is $800, what's going on? Super sophisticated landlords have, on a few occasions, said, here is your security deposit back, okay? And I'm suing you. Why? Because under the statute, if you improperly withhold a dollar of a security deposit, you could get double the damages and reasonable attorney's fees. So a sophisticated landlord says, well, I got some iffy issues. I bought this property. I don't know how old the carpet is. I don't know how old this is. So then I don't know how to depreciate it. So I'm going to play it somewhat safe. I'm giving you your money back, but now I'm going to sue you. That happens once every blue moon. 9 times out of 10, if the landlord thinks he's been damaged $800 and he has a security deposit of $800, he keeps that amount. And he can always be sued. This is America, unfortunately. Ask our president. You can always be sued.
Yeah. So let's say a landlord keeps part of a security deposit. What are they required to provide to the tenant? And then does the tenant have any rights to re-enter the property to verify? Like in the case of, the landlord claims some damages. Can I go back in there hold on, let me see what you're talking about.
The short answer is no. There's no right for a tenant to re-enter. That's another reason why you got to take pictures and videos when you move out. The landlord has a duty to give you an itemized deduction so that if the judge ever has to have the trial within the trial and we got 6 issues, he's got itemization of the 6 issues. And the tenant has a meaningful opportunity to say, I argue about itemization 2 and 4. This is unreasonable. And there's a time constraint. You have to do your security deposit transmittal letter within 30 days of getting the property back. And the property meaning the keys. If you have a tenant that moves out and never gives you the keys technically the 30 days has not started.
Oh, interesting. Interesting.
But a landlord will be in purgatory saying, I don't have the keys, so I don't want to take repossession. I had one case in 38 years. Tenant in Cleveland says, I'm out of here. They leave and don't give the keys. 35 days later, after the landlord cleaned the place and repainted it, the tenant, the mom with 2 kids, reappears with a husband and now 3 kids and says, I went on vacation. What did you do? She went to the Cleveland Municipal Court, filed a motion, and the court ordered the landlord to let them back in, and you just need to evict them through the court process. So they got another like 6-7 weeks of a free apartment. But that's only happened once in 38 years.
Wow. Yeah, that sounds like an extreme scenario.
The key is the keys.
Yeah.
Do I have keys? And if you don't, if you want to be safe, but here, as a businessman, there's been many a times when a tenant would leave one of my apartments and it's like, nah, they're gone. They changed the utilities, there's no food, they're gone. And, if you want to just think as like an MBA, it's like, all right, I'll have 100 cases like this. I might have that one case in 38 years, but the 99 cases allows me to rent these units quicker. And in the big picture of life, I'm still ahead.
Yeah. But also good as a tenant, making sure that I get the keys back as soon as possible to trigger that countdown if, assuming I'm going to get my security deposit back as well. So,
And here's the other thing for landlords. The security deposit transmittal letter needs to be postmarked within 30 days. So here's a warning. Don't put it in a mailbox. If you're up against the timeline, walk into the post office, make eye contact with the postal worker and say, please stamp this. I need today's date. And I've had many cases where the tenants are like, I'm dreaming that it's postmarked 31 days. I'm going to get you. So you got to get it postmarked. Doesn't have to be received, but postmarked.
Understood. What about on the tenant side? What does a tenant have to do to properly provide a forwarding address? How does that affect their ability to recover statutory damages or attorney's fees?
They need to put their forwarding address in writing. Now, the statute does not say you must do it the very first day you move out or when you hand the keys. In fact, right now I have a case where I'm representing some tenants, which is rare. 90% of the time I'm representing landlords. They gave their forwarding address 19 days after they moved out. That's permissible. And they gave it in writing. Now, there's a couple case law where courts have said they didn't give it in writing, but they looked the landlord right in the eye and said, I'm moving to this address.
Yeah.
So the court kind of says, we'll hold our nose and say that's all right. But put it in writing. And I advise my clients, let's say they don't give you a forwarding address. You want to cover your butt? Send it to them at their old address and put to the last known address. And here's another trick, landlords, if you want to find out where your tenant moved to. It's called return service requested. You put that at the top of the envelope, then you address it to their old address. If they have put a forwarding address or a forwarding order to the post office, they will mail you back that envelope with a yellow sticker in the bottom right-hand corner with their forwarding address.
Yeah. For all the heat the post office takes in the world, it does have some systems in place for this stuff.
Right. There are official government system and all that, but make sure you put your return address on that, or else the post office won't know how to send it back to you. And then you can decide, I know where they moved to. Maybe I want to sue them, or maybe I don't. But that's another creative way to know where they are.
Yeah. Well, and I think too, you mentioned earlier, like, I didn't, the tenant didn't put their address in writing or whatever it might be. And I would think in this digital age that we're in now, right? Like, I'm pretty sure my landlord has my cell phone number. He knows how to reach me. He can get a hold of me. And I'm wondering too, if, email is as good as the written letter in some of these cases or not.
Yes. I would advise people that email is a written communication. Now, I advise my landlords, just because I'm a little bit of a stickler, I hate text messages. But if I was a judge, text message is written communication. It's better than just calling up on a cell phone and talking. But I prefer email and
Paper.
Good
Yeah.
old-fashioned paper.
Yeah, no, I mean, it is, I get it, because the digital footprint's real, right? Like, there's times even when people think they've deleted messages that it's like, well, you deleted it from the device, but not from, the server or the cloud or whatever. So,
And that goes to another thing. Never send an email or a text if you're angry.
yeah,
Never.
right.
Pretend the judge is always reading your stuff before you send it out.
Yeah, you don't want to get,
Or the Washington Post, you know what I mean? Never do this. So discretion is very important.
yeah. Well, I mean, that's it. There is some point potentially where a judge is going to make a ruling, and if they see that you were a jerk and threatening or other, it's not going to do any favors, I'm guessing.
I once had a case, landlord tenant. The tenant requested text messages. My client produced 2,500 pages of text messages. Very abnormal. Okay. We had the trial. The trial was on issue A and B. By admitting the text messages, the judge took 6 weeks to read the text messages and decided the case on issue C that nobody even argued. He said, this is an invasion of privacy case. And it's like, what are you talking about? So if you give too much evidence, you can even allow a judge to get lost in the swamp. And from a practical standpoint, it's like, yeah, the judge was wrong. You want to go to the Court of Appeals? No, can't afford it.
Yeah.
So limit what you do digitally.
That's good. That's good stuff. Ed, great talking to you as always. Any final tips for our listeners?
I mean, when in doubt, call your attorney or call me and say, I'm thinking of this deduction. What should I do? Or I've got this fact pattern. 8 times out of 10, the reason my law firm is so busy is people do stuff and then they go, I don't think I should have done this. Can you help me erase it? And it's like, no, I can't help you erase it. But the purpose of a good lawyer and a good accountant is to save you money rather than being an expense.
Right.
And hopefully that's what our law firm will help you do. Save you money instead of being an expense.
Yeah. That's awesome. Well, Ed, thanks very much. Good to see you, and I know we'll talk again in the near future.
Thank you, Sean.
That's it for today's episode of the Ohio Eviction Playbook. If you want to learn more about Ed Kasputis and his work helping landlords and real estate investors navigate Ohio eviction issues, visit his website, KasputisLaw.com. I'm Sean O'Connor. Thanks for listening. And don't forget, subscribe, share a link, leave a review. It's all helpful. We appreciate it. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.